We went live. Okay. Hi, everyone. Is everyone eating their lunch, or what are you doing? Just taking a quick break. We appreciate you being here. Hi, Dizzy. I'm just going to say hi to you. Bring in the dancing lobsters. Good morning. I don't think we know each other. Hey, Sheila. Okay. Welcome, everyone. So if you guys are not familiar with Martin, he's awesome. He's a trial attorney. He's been really wonderful at breaking down certain things in the Karen Reed case, among many other trials as well. You can go to his channel at Brother Counsel. And one thing about Martin that I'll say is that I believe he truly is one of the only unbiased attorneys that have, I'm not kidding, that have covered this case. I mean, yes, you give some opinions sometimes, whatever, but you generally are so unbiased. You just say the facts and you say, hey, this happened based on, my experience. This is what we did. So he's awesome. So what we're going to do right now is we're going to start by breaking down the motions from yesterday, the newest motions filed by Alan Jackson. And then I'm going to play a video for all of you that you might have seen on Twitter. It's circulating, but when I watched this video, I was like, oh, okay, wow. And Martin, you know the video I'm talking about. It's the verdict in the David Swift case out of Tennessee. So that's super interesting. I'll play that in a bit. But Martin, would you prefer that I pull some of these filings up on the screen, or what do you think?
Whatever works for you. I'm happy to talk about whatever, however you want to do it.
Okay. Hi, Sal.
I've read it, obviously, the entire motion, beginning to end. We can talk about different pieces of it. If you found something interesting to put up for everybody to watch and follow along, that's fine also.
Yeah. Why don't I do that?
Okay, well, just something everyone should just keep in mind, when you're looking at these filings, and, you get these filings all the time as a lawyer, and, lawyers can be very wordy, and they can take 30 pages to make one argument. And one of the things that, you want to help yourself when you get these 30 pages and you don't want to feel like, oh my gosh, I'm going to spend the next 4 hours going through this and sifting through and looking up the case law. You really want to figure out, okay, really, what are they arguing? What is the main point of this argument? And what does it come down to? And then once you have that, then you have that framework, then you can kind of start working on your response and understanding exactly what they're saying, pinpointing on what you're researching. So you can show whatever you want. This motion in my mind comes down to really is there's really two main arguments in this motion. We can break it apart however you want. One of them I think is less meritorious, and the other one is actually interesting and has more merit. And of course, what I'm finding is that a lot of people are reporting on what I believe is the less meritorious argument, as opposed to what I believe is the more meritorious argument. So,
okay, well, let's start with what you think is less.
Okay, well, the less is obviously the one that's more exciting and the one that everyone wants to talk about. It's the conversations that the jurors had with Alan Jackson and an intermediary with an informant who then told David Yannetti. So the 3 levels of hearsay there. But there's really one juror who has been directly in touch with Alan Jackson, and then there's 2 other jurors I have been in touch with intermediaries who have then been in touch with informants who have then been communicating to David Yannetti what the jurors have been saying. So that's
okay.
Really,
so this is a lot of hearsay, like you said, and how are they going to prove this? Are you allowed to bring back the jury? And that might sound like a dumb question, and I'm very sorry, but hopefully other people were thinking that too.
Right. No. So the truth is that to bring back the jury would have to be something really, really crazy. Like, I don't know if everyone's been following the Alex Murdaugh trial. So there was some allegations that Becky Hill was tampering with the jury. So if you're going to get into jury tampering, that is serious enough to require the jury to come back and get everyone back, have an evidentiary hearing. The question is what they're alleging in this motion going to be strong enough for the judge to say, you know what, we have to have an evidentiary hearing, bring all the jurors back? And the knee-jerk reaction is that it's not going to happen. The judge is not going to bring back a jury and start doing evidentiary hearings to hear what they have to say. Now, in terms of the hearsay, to respond to that, in terms of the hearsay doesn't really matter that much in a motion. Okay, so this is a motion that you file with the court. We always attach affidavits to motions. Affidavits are themselves hearsay, even if they're from personal knowledge. The affidavits themselves are hearsay. You never see an affidavit being admitted into evidence because they're hearsay. But what it could do, and what you're trying to show the court when you're submitting affidavits or other pieces of hearsay as part of your motion, in support of your motion, is to show the judge, look, this is a serious issue. People are willing to swear. That's what an affidavit is. You're swearing under oath that certain things happen. Now, of course, that's not admissible, but it's much more attention grabbing to the judge. And then that will then prompt the judge to say, okay, well, then we do need to discuss this further. We do need to have an evidentiary hearing. So the fact that there's so many levels of hearsay here is not dispositive. It doesn't mean that, okay, well, it's all hearsay, then she's going to throw the whole thing out. It should make a judge pause and say, okay, this is a serious enough issue that we have to go further and see what we're going to do with it. So that alone is not dispositive, but still, the fact that there's only one juror who directly spoke to Alan Jackson. And remember, in the Alex Murdaugh case, I don't know if you were following that, Lauren, but in the Alex Murdaugh case, the jurors themselves submitted affidavits. They themselves signed affidavits about some of the conduct that was going on with Becky Hill. So the closer you get, obviously, to the person who's saying the conduct, the juror, the stronger of an impression it's going to make on the judge. So here, the closest we have is Alan Jackson saying that a juror reached out to him. That's the closest that we're going to get. And again, it's only, even if we were to accept everything that the jurors are saying, that's 3 jurors. 3 out of 12. Who knows what the other 9 are saying? And when this first came out in the Alex Murdaugh case, when we were talking about jury tampering, well, what did the other jurors say? And then some of the other jurors said, no, there's no jury tampering. So, just to right away say, well, the three jurors say that it was 12-0 on the second-degree murder, that means that everyone agrees to that. Well, some jurors actually may come back and say, no, that's not true at all. So
wouldn't that be a reason to bring them back then, to get information from all of them, because this is so serious and this is pretty crazy, right? Sorry, I froze.
Right. So we have to look at the substance of what the allegations are. What's the substance of what the jurors are either saying in their affidavits or what the attorney is representing that the jurors told them? And here, all the jurors are saying is that it was 12-0 on the second-degree murder. And that's really an area where you're saying, you had your chance to deliberate. You could have asked these questions to the judge. You could have made this known to the judge. You didn't. Your chance is over. You can't go back and rewrite history now. So what I would say, this is what everyone's getting excited about. I think, but some of the reports that I've heard, the jurors are saying it was 12-0 on the second degree and the third count. And therefore, one of their first arguments is therefore that really Karen Reed was acquitted. And that's why it's double jeopardy. That argument, in my mind, is just not so persuasive, and it doesn't hold that much merit because you can't go back and redo jury deliberations. You had your chance. Once you leave that jury room, this is what they call invading the sacred province of the jury deliberations, and you can't now redo it. So that part of the motion, I don't find, as a lawyer, I don't find that so persuasive. It's much more the other part, which I thought interesting, novel, and more meritorious with what they're looking for in the relief. So we can get to that also. I don't know how you want to do it, but we can get to that part also.
No, I want to. Sorry, I had to stop my camera because I'm frozen. So I want you to keep going. As long as you can hear me, that's good, and I can hear you. I'll get back up eventually. But I just, this is so crazy, and this case in general has been so crazy. So when this came out yesterday, do you think there's any connection to the initial jury verdict slip and these issues as well?
Well, again, if there's any sort of confusion with the verdict form, the time to voice that concern or confusion is during jury deliberations. If you have problems with the verdict form, you come back to the judge, you write a note, say, we don't understand this verdict form. It's confusing. And then the judge will give you some more instructions, or try to explain, or ask the attorneys, maybe we can do a new verdict form. But it's possible, again, it's possible that the jurors were confused by the form, and that's why, and there were some mentions about that in the affidavits, that they felt that the form was very confusing. Well, if it was, and this is what the judge is going to say, almost guaranteed, if there's any problem with the verdict form, the time to bring that to my attention was during the jury deliberations, not afterwards to an attorney. That's not how this works. And we can't now go redo all of the jury verdicts that came out because some juror speaks out 3 years later, oh, I was confused by the verdict form. So those arguments they're just not going to fly. You're going nowhere in a hurry with those arguments, which is why, Lauren, when I first heard about this, as soon as I heard about it yesterday, like during lunchtime around this time, as soon as I heard about, some jurors are saying that, there's confusion and really they wanted to acquit. Right. I was like, I'm not going to waste my time even thinking about this or reading it because I know exactly where this is going. This is much more for posturing. It's much more just for the headlines. It's much more just for the publicity and to let the Commonwealth know that there was 12-0 on the second-degree murder, and maybe that will convince them not to retry Karen Read, at least on those charges. But I didn't think that there's any really serious merit to it. When I started actually reading the motion, then I saw the second part, and the second part is what piqued my interest and which I thought was worthwhile discussing. And there actually may be some merit to that.
Okay. All right. So do you think that on July 22nd, this is pretty much what's going to be discussed?
I don't believe there's going to be a hearing before then. I can't imagine that there's going to be a hearing before then. They'll probably discuss it then. Again, I don't know exactly what the rules are. I didn't look up the exactly rules of procedure to see how much time after a motion is filed that the Commonwealth has to respond. If it's within 7 days or 10 days, or then maybe they will have to file a response before the status conference. I don't know for sure. But I think what you're saying is true, that the judge will want them to come to a conference before they start, to see kind of where the Commonwealth stands on this issue and see what they want to do in terms of the procedure of how to go about with this motion. So they may do that. The judge may tell them beforehand, in that, I'm not inclined to bring the jury back. And again, I think 99% of judges would do that, like with these type of allegations. But again, I think it's really much more the other novel argument, I think, which is may hold some weight here, which is very interesting because this case is just every day there's something more going on.
Yeah, no. And so since I'm still frozen here, I don't want to mess anything up, but I do want to read a question. Taryn said, I still find it strange a juror reached out to the defense. Why didn't they contact the Commonwealth, or did they possibly? And did the Commonwealth brush them off?
Right. So jurors, especially when you have a juror who voted to acquit, they'll think that they align much more with the defense. So they'll reach out to Alan Jackson, and the Commonwealth and the prosecution is probably a little more difficult. Maybe they're more difficult to get a hold of. Maybe they did voice their concerns to the Commonwealth. That's something that we can also find out more if this ever gets even opened up into any sort of hearing about this. But yeah, I think that's a reasonable point, that it could be the jurors actually did reach out to the Commonwealth with all the misinformation out there about where the voting stood. And I think, how many reports have you heard, Lauren, about the different where the voting was standing?
Oh my gosh. Yeah, like way too many. It's crazy. Because I do follow both sides, or I should say both sides of where people stand on this case. And each side absolutely unequivocally says, nope, it was 12-1, or nope, it was, in their favor. And I'm like, oh my gosh, it's intense. And I don't always know who to believe, who to trust. And I don't have, I guess, enough information to dig on this myself. And that's one thing that's tough with the jury. You really don't, as a reporter, I guess, or as a journalist, it's very, very tough to dig unless you are there. And you've made yourself, I guess, a part of this and a sounding board.
Yeah, and the jurors could have, by the way, they could have just done an interview with one of these stations or one of these reporters like you, Lauren, and they could have said, hey, we want to talk about what's going on, or we want to, give you an interview and tell you what was going on in the jury room. But again, there's a lot of times they have like these private chats with the jurors between themselves, and they kind of agree about whether they're going to talk to the press, whether they're going to give any interviews or things like that. And, that still may be coming down to, maybe they feel, until this is all completely done, we're not going to talk out. That's possible. By the way, I did see in the comments, Dizzy said that Rule 15 says they have 7 days to respond. I think I saw someone 10 days. So we may see a response.
Ooh.
And I think that would be very interesting, especially, as a legal mind myself. I would like to see the arguments back, some of the research back. I don't have the liberty to go and, go and spend a few hours on this researching, but the little bit of research I did yesterday was a very interesting issue. What actually I think may hold some merit in this case.
Now, Sue, do you see, Sue asked, do you think it's true some of the jurors are afraid due to all the circus surrounding this trial, which I definitely think so.
Yeah, absolutely. I mean, even me, just being an objective lawyer, just talking about this, I've gotten people saying, how can you just come out? And I'm not even taking sides. I'm just pointing certain things out. I did voice my opinion that after all the evidence was in and all the facts, became clear in the trial, I do believe that there was reasonable doubt. So I expressed my opinion after I saw all the evidence come in, and even just expressing my opinion in that way, very clearly not taking sides. I've, had people telling me I shouldn't get involved with this trial. It's just, who knows what's going to happen. And, it's,
that's not even, I feel like that's not even, that's not necessarily an opinion. I do believe that's pretty factual. There was a lot of reasonable doubt in this trial. You don't have to think any guilt, any innocence. That's just factual. Absolutely.
Well, factual and opinion actually have a legal definition, Lawrence. So,
without getting into calling me out.
No, I'm just saying, instead of getting into the legalese, exactly.
Yes.
If at least before, it sounded like there were some jurors that did feel that she was guilty. So, if they determine what the facts are, juries do determine what the facts are. Then, the fact could be that some people, that there wasn't enough evidence to convict her or whatever. But the point is that, I can completely understand that why jurors do not want to get involved in this entire escapade and start having who knows what type of threats or demonstrations outside their houses, or who knows what can happen. So I understand that.
Yeah. And I want to go to Tiffany. Tiffany says, why do they make them so dang confusing? Also, when did they have one question? The judge said, you have everything you need, go back. Maybe they didn't think they could get help. That is kind of interesting.
Well, again, that question, I think if I remember correctly, what question you're referring to, you're talking about the question of they wanted to see a certain cert report, right? And the judge told them, you have all the evidence to make your determination and you're not getting any more evidence. So that was a very specific question with respect to specific evidence. This is other questions. So just because the judge is letting you know about an answer to a certain question doesn't mean that you're going to be shut down for any other question. You're free to ask whatever question that you want.
Yeah. And let me see somebody said something. I just want to make sure I get to it. I would think by now, P. Lola's mom, most jurors have seen a lot of the news and the YouTubes, and this is sus once again. And I agree with that. There's no way they're not looking at everything after this is all said and done.
100%. And that's exactly why the judge is not, I don't think the judge is going to take any of this too seriously, what jurors say a week after jury deliberations are over, because let's say you had a juror who believed that she was guilty, and then she followed Brother Counsel, and then she saw why that didn't make any sense. So, then she's like, oh, you're right. I should have never voted that way. And now he wants to take that back. So,
yeah. And Dizzy, just going back to the judge, she said, Bev didn't give them a chance. Apparently she didn't even tell them it was a mistrial until they came out that last time, and then they were discharged. So they couldn't ask.
Yeah. But again, if they had some confusion, if that was the reason why they couldn't get any sort of verdict in this case, because they had some confusion with the jury, with the verdict form, then, as you're filling that out in the jury room, you should say, well, we just don't understand this. So before we say that we're deadlocked, because we're not, according to what the reports are, if we're not deadlocked on the second degree charge, and we want to write here not guilty, can we do that? And that could be a fair question. Can we write not guilty? And I've had questions, by the way, in my trials where the jury will ask a specific question on how to fill out the form. When you ask this question and there's a certain number, let's say for me, it would be a lot of what I do now is civil work. So if there's a line for damages, so there could be a number of lines for damages, and they may ask, do we have to put a number by every line? Do we have to, and ask specific questions exactly how to fill out the form. And if that's really what happened here, they had business asking the question during the jury deliberation. So to come back now and say, well, we were confused about it and therefore, we want to redo, it's just not going to fly. You're going nowhere in a hurry.
Yeah, yeah. And so is it normal, Martin, for a judge to discuss, I guess, the separate charges in your experience? Or maybe, you're in Michigan, this is Massachusetts. Is it normal for them to go through the charges with the jury and then declare a mistrial? Or is it just kind of like what Bev did?
Yeah, well, it's hard to say what's normal because it doesn't happen that often where, they want to fill out one part of the verdict form, guilty or not guilty. And, these type of questions come out. I've never experienced anything like this specifically. But like what you've seen, you're going to show that clip where the judge specifically did do that. And that's part of the argument that they're actually making in their motion to dismiss, that this was an alternative consideration that the judge should have engaged in. And maybe there would not have been a hung jury or a mistrial on all 3 counts.
Yes. So. Yes. Okay. Yeah. No, that's super interesting. So I do want to play that video. So what I'm going to do is let you talk for a minute so I can get myself unfrozen to play that. So let's just go really quick to a question. I'll let you answer these while I just quickly reboot myself. Lola's mom, when is the hung jury? Do the jurors sign off on the jury form? Do they write where the problem is when they can't agree? And then Tiffany, I'm wondering why the judge never asked to look at the verdict form, even with the mistrial, just to make sure nothing was filled out. I'll let you go through that for a minute, and I'm just going to reboot.
Yeah, I imagine that they didn't fill out the verdict form, and that's why they never submitted it to the judge. I don't know if the judge actually specifically said, let me see the verdict form. I didn't hear that, but she just was reading the notes, which said we can't reach a unanimous verdict, which she understood to mean that they didn't write anything in the verdict form. So the judge did not look into the verdict form. And therefore, she just assumed that everything was just hung and they couldn't make any determination about any of the charges. Do the jurors sign off on the form, on the jury form? When is it a hung jury? No, they don't. And that's part of what they're sending notes back and forth. And sometimes you get the jurors out, and as the jurors will come out and the judge maybe will be talking to them about, that the fact that they're hung or that they're going to, she's going to order a mistrial. That's really when they do it. Welcome back, Lauren.
Thank you so much. Okay. So you guys, I do want to play this right now because it was pretty eye-opening to me. Let me just make sure I didn't miss any questions. Sorry. Sal, really quick, said, what if the jury says we don't know how to fill out the form, but the judge says fill it out anyway? Will they be held in contempt of court? I mean, Martin, yeah.
No, they're not going to be held. No, the jury's not forced to do anything. I mean, the jury's not forced to fill out a form if they can't come to a consensus on any of it. If the judge says, if you agree on charge number 1 that it's not guilty, then write not guilty, then the jury should write not guilty. Now they're going to be held in contempt and they say, well, we decided not to write not guilty. No, because that's invading the province of the jury deliberations. Who knows? Maybe when they went back to jury deliberations, which is, by the way, one of the cases, a very interesting case. If anybody here is a legal nerd like me, if you want to look up this case, it's called Bluford versus Arkansas, which is one of the cases that was quoted in the defense's brief, which, again, this was a very similar situation. They couldn't come to consensus. The judge sent them back, even though they already said on the record, they said this on the record, that we agree that they should be not, this defendant should be not guilty for first-degree murder or capital murder. And we just can't agree on one of the other charges. And the judge says, okay, well, we'll send you back for deliberations. They came back with a hung jury on everything. And the defense was arguing, well, they already acknowledged that they want to acquit on the first-degree murder. And there, the reasoning was, well, when they went back to that jury room, before they submitted the form submitted the note that said that they're hung, they could have had some more deliberations. And in that deliberations, maybe somebody changed their mind. So, that can always happen. So
tell me what that case was, just so I can write it in the notes so people can look it up.
Oh, yeah. It's Bluford versus Arkansas.
How do you spell Bluford?
Blue like the color and Ford like the car.
Easy peasy versus Arkansas.
Yeah. Very interesting case.
And then Yeah, Alpha Fox Adam, Brother Counsel noticed that the jury note said impasse on the charges. I think that was very informative.
And that was informative, and that was exactly actually a very important part of their motion. They included that in their motion, the fact that they said the charges, but the question is, what charges? Are they talking about all the different options in second-degree murder? I'm not second-degree murder. The count number 2, which was involuntary manslaughter.
Oh, yeah, sorry. That the first is murder 2, involuntary manslaughter, and then leaving the scene.
Right. So maybe they're talking about that second one, which you showed before, by the way. So that's part of what they do make a mention about in their brief. Certainly go take a look at this motion and brief that they filed. They do talk about that.
Yeah, I'm not going to put it up again because I think that shit caused me to freeze. So that's not happening. Amber said this. This is interesting. Judge told them only to fill out the verdict form after they reached a unanimous verdict. I would think that they would need to clarify with her about certain things, right? I mean, that you can't just, or if that's what they were doing in there, they were trying to, I mean, yeah, I don't know.
Yeah, well, here's the thing. I mean, they did reach, if we're to accept everything, then they did reach a unanimous verdict on the first count and the third count. So fill that out, fill that form out. So, I mean, that's part of what's going on here.
Okay. And just for new people joining, I see a few more people have joined the live. I'm Lauren Conlon. This is my channel, Pop Crime TV. It's pretty new, everything I'm doing. So make sure you give it a like and a subscribe and follow me. And obviously, you know, Brother Counsel. He's incredible. His analysis across many trials is amazing. I like Martin as well because he does these analysis in 45 minutes or under, and I like to play it on 2 speed or maybe 1.5, whatever, and I just really get through it, and it's just super informative. So everybody give Brother Counsel a follow as well. Tommy just said, hi Tommy, what if Beb said charges ad-libbing since she never showed the note? Let the conspiracies run wild.
Well, the notes usually become exhibits. So they usually do become exhibits, and therefore you should be able to find that question out, whether she actually read that note correctly or not. So it should be part of the file. All right.
Well, I'm going to play this video now. Guys, this is the judge in the case of David Swift. David Swift, it was the state of Tennessee versus David Swift a few months ago, and he was accused of murdering his wife, Karen Swift, maybe 11 years ago. This case took forever to get to trial, and they really, in my opinion, they lacked evidence. They had circumstantial evidence, but they lacked physical evidence. And I personally felt like the state did not meet their burden. And I thought that David Swift was going to be found not guilty. So I'm going to play this for you guys, and you can see for yourself. Okay. How it's supposed to go. And Martin, if you have anything to say, I'll stop and just replay.
Good afternoon to you all.
Can you hear that, everyone?
Has the jury verdict in this case?
No, Your
Honor. Do you feel like that it is likely that the jury on continued deliberations will reach a verdict?
No, sir.
Let me ask you this. Has the jury considered the highest level of the offense?
Yes, sir.
Is there disagreement as to the highest level of offense?
Yes.
That's where your disagreement falls.
No, I'm sorry. It is not. That is not the case of the highest offense.
Okay. Does the jury agree on the highest level of offense that the defendant is either guilty or not guilty?
Yes.
What is the verdict in that?
Not guilty.
Okay. So the jury has found the defendant not guilty of first-degree murder.
Yes. Yes.
Okay. May I borrow the charge book for a minute so I can look at the verdict form? If you need it back to look at it, just tell me. Has the jury considered the second level of the offense attempted first degree premeditated murder?
We did consider that.
Is there an agreement that the defendant is not guilty as to that offense?
Yes, there is an agreement.
Has the jury considered the level of offense second degree murder?
Yes, sir.
Is there an agreement that the defendant is not guilty as to second degree murder?
Not guilty.
Yeah.
There
Okay.
you have it. Now, there you have
Yep.
it. That's exactly what Alan Jackson is, David Yannetti, actually, he's the one that filed the motion, but that's exactly what Karen Reed's defense is arguing should have happened in this case. They should have went, count by count and asked them, whether they're hung on each of the accounts. So that's the argument here. Now,
Yeah. Watching that was like crazy eye-opening. I was like, oh, so that's what they probably should have done. And again, I'm not a lawyer. I don't know the law as well as you, and I don't know the law in every single state. That was Tennessee, as I mentioned, but I was like, holy moly, things could have gone a lot differently if what this juror said, in fact, was true.
right. Well, I did see a comment here. Somebody asked about notes, whether the lawyers get to see the notes that came in from the jury.
Here. Let me see. That one?
Well, there's
Tiffany?
one of them, but then I also saw some.
Okay.
So actually, I have seen some notes where the judge asked, where the judge was asked a question by the jury. He doesn't have to show it, or she doesn't have to show it, but I have seen them. Sometimes he'll call us up to the sidebar or whatever. He'll show us the note just to show us that he's reading it correctly.
Mhm.
But he doesn't have to. And many trials, they don't. They just read it and they mark it as an exhibit. And, if you want to pull the exhibit later and show that he read it wrong, maybe you can do that. But yeah, I don't think there's no rule, I believe, or case law that says that I'm familiar with, at least, that says that they have to show it to the lawyers, but I have seen them.
Right.
But
And I want to say something. Sorry to interrupt you. What were you going to say? Finish your train of thought.
no, go ahead, because I want to move on also to what I believe is the more meritorious argument here in the motion, because I think to argue for acquittal because the jurors are now coming out and saying it was 12 to nothing on second degree murder, like I said, I don't think is going anywhere. To say that therefore she's acquitted on the first and the third, and therefore the retrial and this double jeopardy because the jurors are now coming out and telling us what their voting stood at. That's going nowhere in my opinion.
Well, I guess part of me does believe what this juror is saying, because me personally, I always thought murder was a stretch. And this is just based on everything that I heard in the trial and everything that I read beforehand. But I was always like, man, murder is a stretch. So I do believe that they could all agree that this wasn't murder too. It wasn't intentional. I fully believe that. But again,
right, but Lauren,
it's
whether we believe it or not, it's not going to. They're not going to now enter.
No, I get it. I'm just stating my opinion here because it's YouTube and it's my opinion, where I'm like, I believe that part, that they most likely did come to a conclusion unanimously that she wasn't guilty of murder. But yes, I totally believe they were hung on manslaughter. 100%. I could believe that. 100%.
By the way, I do want to say something. When I try cases, and again, I'm not trying to say anybody did anything wrong here. They only had an hour for closing arguments, and this case went on for 30 days. There's a lot to discuss. There's a lot to do. But somebody made a mention that the jury instructions were very confusing, or the verdict form was very confusing. What I always like to do in my closing arguments is, number one, I explain the jury instructions. So I'll put up the jury instruction, and I'll go through them carefully. I know that some lawyers don't even care, or they argue about them, but they don't actually talk to the jury about them. And I think that that's important, to let the jury understand and make sure that they understand. And one of the things that I also cover in voir dire when I'm in trial or during closing or whatever, I say, if you ever have a question about any of these jury instructions or the verdict form, write a note, because we want your verdict to be, 100% with clarity. So I always stress that, but also I explain the jury instructions. And also what I think is so important, and again, Alan Jackson only had an hour, is to go through the verdict form. I'll put the verdict form up on my slides and I'll say, this is the verdict form you're going to get. And I'm going to go through each one. And if I was Alan Jackson in this case, I would say, now, if you all believe that Karen Reed is not guilty on second-degree murder, you got to write not guilty. And if you can't figure out the rest, or you're hung on the rest, you got to let us know that you all agree that she's not guilty on second-degree murder. That would have also helped the situation out a lot. So I think that that's also something that I noticed. I didn't discuss it so much because, you only have an hour and there's so much to go through, but that's an important part.
Right. That should have been like, I didn't even think about that. They only have an hour. It would have been really wonderful and informative if they each had a chance to explain this and tell the jurors what they are supposed to do when they fill out the form. But Dizzy saying she said from the get-go that she was not going to poll. I don't remember. I don't know if you recall, Martin.
Well, I do recall, Lauren. I think that our last live together was during the jury instructions. So I don't know if she actually said this during the jury instructions, whether she's not going to pull the jury, or maybe this was after she got the notes. Generally speaking, with a mistrial, you don't pull the jury. You don't go through each person, because usually the idea of pulling the jury is when they come back with a verdict. And then you go through each person saying, is that and was that your verdict? Yes or no, meaning guilty or not guilty. But if it hung, then you don't have to, then there's no right to know who held guilty, who felt not guilty. So that's, most what I've seen is that they don't pull the jury when it comes to a mistrial. But let's kind of move on.
Hold on. I just one last thing. We will move on. Maybe the judge felt that doing count by count too time consuming, or maybe Tennessee courts don't necessarily do count by. Okay. Well, I just want to say, Sal, if you did not, I don't think you watched this trial as closely as we did. Judge Bev was very tired. She made it very known that she was very, very tired. She was very sleepy. And I think towards the end of this, and look, I get it. This is a long trial, very long. But for me, it was kind of clear she was just done. She was like, I don't want to be here. I don't want to do this anymore. So, yeah. And I think that was pretty clear to everybody that she had it when she discussed Alan Jackson and the jury slip, and when she called out Karen Reed. Something funny, Miss Reed. I was like, oh, she's done. But yes, let's move on. Martin, let's move on.
Yeah.
Let's go to part 2.
Okay, so which I think is really the more interesting one, and maybe the more legal one, which is why it's not as exciting. So only exciting for lawyers like me. So this is also what I explained. I did a whole video on this last night. So if you want more of a deep dive, certainly check that video out on my channel that I dropped last night. But the idea is like this, right? There's double jeopardy. So double jeopardy can either be that you're acquitted on certain of the charges, and therefore you can't obviously be tried again for those charges. And then there's double jeopardy by the fact that a mistrial was declared, and the fact that the mistrial was declared was inappropriate. Okay, so even if we ignore all of those jurors and all those affidavits and just ignore it all, the question is, by the way that the judge ordered a mistrial in this case, was that proper or not? And if she did it in a way that's improper, that can also cause double jeopardy. And that's where it gets a little more legal and a little more interesting, because here the idea is the following. If a mistrial is entered without the defendant's either consent or request, okay, so if the defendant did not request a mistrial, or if the defendant did not consent to the mistrial, that can also trigger double jeopardy. Now, what happens in a lot of cases is that when you get a note like this after an Allen charge, or in this case, a Tui Rodriguez charge, they'll bring the note will come back to the judge. The judge will then call the attorneys before she calls in the jury. She'll call in the attorneys and say, okay, this is after the Allen charge or after the Tui Rodriguez charge. And now I got this note. They're just deadlocked. They're at an impasse. And I'm giving each side an opportunity to tell me what you think I should do. And the Commonwealth will say, well, I think that they should deliberate longer, right? And most of the time, the defense will say, well, at this point, Your Honor, I think that we should order a mistrial. There's a request, right? And that's what the defense wants. They want a mistrial. In case the voting is, 11-1 in favor of guilty, you don't want to lose that one. So you'll say, Your Honor, I think that it's time to move for a mistrial, to order a mistrial. And 99% I'm almost certain that if she would have asked that question, Yannetti would have said, Your Honor, it's time to order a mistrial. And then this whole motion would be out the window. But she didn't do that in this case. Here, she got the note. She calls the attorneys in. She says, the jury's at an impasse, call the jury in. So before she even reads the note and talks to the attorneys and let them make a record, she calls the jury in. She reads the note to the jury, and right away, without even giving anybody the opportunity to object or make a record or anything, she says, I'm ordering a mistrial. I'll be in to see you soon. Have a nice day. Right? So is that consent? Was that consent by the defense? Was that a request by the defense? No. So now you have a mistrial that's been ordered without the request of the defense and arguably without the consent. Now you may say, well, why didn't Alan Jackson object? Right? As we know, you're not scared to object in this trial. So when you said, Your Honor, I object, maybe I need to make a motion or I want to talk to you out of the presence of the jury, but he could have right away jumped up and said, I object. And I want to make a record before you order a mistrial, or even if you just order a mistrial before you make it final, I want to make a record. Now, they did pull some case law. The defense pulled some case law on this, and this is found in the motion, that the fact that they did not object does not mean that they consented. So that's not dispositive either. So you can argue there's a very strong argument, in my opinion.
Taryn, I see that too. That's very interesting.
Right. So there's a very strong argument that, number one, this was not a request and it was not with consent, but you're not in the clear yet. Okay.
Okay.
Should we stop here?
I put this up. Dizzy said the defense seemed happy to accept a mistrial. I don't think that I think they were just done with the jury going back and forth and coming back and saying, we're hung. Here's another note. We're hung. That's what I took it as. But that's just me.
No, I think that they would have been very happy with a mistrial. Anybody would have. Anyone who's trying this case on behalf of Karen Reed, if you get a mistrial, that's a victory. Okay. But here, if this would have played out the way that I said it, I guarantee you that if the judge would have asked Yannetti, what should we do without the presence of the jury, Yannetti would have said, you should order a mistrial. Guaranteed. No questions asked.
Okay, so
the fact that he didn't
agrees with you.
right. No, the fact that he didn't actually, the fact that she didn't do this process now may come back to haunt them, because now you can argue, well, this mistrial was ordered and it was improper, and therefore it's double jeopardy. Now you may ask, well, what's the big deal? You have a new jury come in and try it again. Well, the reason for that, there's some also interesting case law. This is all very exciting for me, probably very boring for everybody else, but there's some interesting case law that says, no, if a defendant wants a certain jury to decide their fate, and that's the jury that's sitting in front of them, you can't just dismiss the jury and say, you know what, we're going to call a new jury. They'll be fair and impartial. Everything's going to be great. We'll try this case again. No, you're not allowed to do that. So here, Karen Reed can make the argument that we were very happy with this jury. We wanted the jury to continue deliberating, or whatever. We could have made an alternative argument what should have been done in this case. But the fact that they weren't given that opportunity at all, that's what they're hanging their hat on, to show that this mistrial was ordered and it was improper, and therefore double jeopardy attaches. Now, I do want to say that there's one very important part that I didn't say about yet. Okay. The other part is the following, that there's another caveat here. Okay. I just left it for the end. The caveat is that unless there was a manifest necessity for the mistrial. Okay. So now that's some more legalese. Manifest necessity. So if the judge felt, even if the defendant did not request, and even if the defendant did not consent to this, but if there is still manifest necessity to order a mistrial, then she's allowed to do that, and double jeopardy does not attach. Well, how does that work? Okay, so what is manifest necessity? Well, the case law is clear, and something that I pointed out in my video last night is that the defense actually did not quote this case because this hurts them. So, but the case law says
what case was that? Just so I'll put it in the notes.
There's some case law here. This is Thames versus Commonwealth. Thames, THAMES versus Commonwealth. There's a number of cases like this. Commonwealth versus Andrews. All right. And that's where the cases say the following, that manifest necessity, what they call a classic basis for manifest necessity, is the trial judge's belief that the jury is unable to reach a verdict. So then that would be a proper order of a mistrial. So if the judge feels like in this case they had so many hours to deliberate over this, well then that means that that's manifest necessity. What are we going to do? Force them if the defense doesn't consent or the defense doesn't request it? We're just going to make them deliberate for all time. So obviously manifest necessity, exactly, right? So obviously manifest necessity could be that there is a hung jury. But there's another caveat. Are we getting too complicated now?
Hold on, but I just want to go back really quick, just because Tommy, I posted his comment before, and we went over this. He said, should they have objected? And you pointed out it doesn't matter at this point. It's not held against them at all.
Well, that's what the case, again, that's the case law that the defense quoted in their brief, showing that the fact that there was no objection does not mean that they consented. They quoted some case law. Now, it could be the Commonwealth. We'll do some research and find some case law that says that they do have to object. And then you're going to have this argument play out. But that's why we have to see what the Commonwealth is going to file in this case, which is why this is so, to me, this is so interesting. Now, there's one other
I'm sorry, can I ask one thing? One more thing. I don't want you to lose your train of thought, but I just want to know, how would they have known necessarily to object on a mistrial where what am I trying to say? How would they have known to, assume that these 3 charges, the jury possibly could have been unanimous on 2 out of 3, 1 out of 3. How would they have known that if everything that's being said and read out loud to the judge is extremely general, like extremely? It's just like, we're at an impasse. We can't decide. How would they even know that possibly they were agreeing unanimously on certain charges?
Well, sure. Well, after learning all that we've learned in the past 24 hours, what you would say is that, well, Your Honor, before we issue a mistrial, I think it might be prudent to ask the jury if they agree on any of the charges. Now, as a defense, you want a hung jury. So this is not normally what goes through the brains of a defense attorney. You want a mistrial and you want to get out of there, right? That's what you want. So practically speaking, this happening is not so practical. But if you want to know technically, what could they have done? They could have said, Your Honor, we object to you ordering a mistrial at this point. I think what would be more prudent is to see whether they agree on any of the charges, and then let's see if they're only hung on some of the charges exactly, and then do a little bit more deliberations in that way. So that could have been done. But let me finish this thought out, okay?
Please, we'll go back.
Okay, so we've gotten through the idea of requesting a mistrial or consenting to a mistrial. So we can make some strong arguments that there was no requester and there's no consenter. But does this mean, was there manifest necessity for the judge to order a mistrial in this case? And here, it's not so simple just by the fact that the jury is hung that automatically means manifest necessity. Why am I saying that? Because they also quoted some other case law. And the other case law says the following: if the judge feels that there is manifest necessity, then there's 2 things that the judge has to do on the record, it would seem. Number 1 is that the judge has to give the counsel full opportunity to be heard. So if the judge is going to rely on manifest necessity, and that's what she's saying, defense counsel, I know that you don't request a mistrial. I know that you're not consenting to a mistrial. I'm going to order a mistrial anyway because I feel that this is manifest necessity. Here's your time to convince me otherwise. And give the defense an opportunity, a full opportunity is the exact quote, to be heard. Was that done in this case? No. And that's why the defense argues in this case, the fact that they were not given full opportunity to be heard, that alone throws out the whole notion of manifest necessity. Number 2 is the fact that the trial judge also has to give careful consideration to alternatives to a mistrial. Did you see the judge go through any sort of careful analysis or careful consideration of alternatives to a mistrial? No.
She was tired, okay?
So if you're going to try to hang your hat on the manifest necessity, you're going to have a problem with these 2 requirements that you have to do also in order to find manifest necessity, which is why, even though initially when I heard this motion, I was like, okay, this is just for headlines. This actually is an interesting, compelling argument. This is a very strong argument in my mind.
Wow.
Now, do I think that the judge is going to order that she cannot be tried again? And by the way, I think that this would bar all charges on all the counts. That's my opinion. I mean, if this is actually
You-
according to the
because
case law,
of
they
what
follow
you
the case
said.
law.
Right.
Exactly.
They'd have to throw
I
out
mean,
everything.
all the
'Cause how do you leave
the
the
mistrial
Yeah.
on every single count, therefore was improper, and therefore she completely be free and not be charged again because of double jeopardy. So what the Commonwealth is going to respond to this part also, I think, is very interesting. I want to see what they have to say about this. But do I think, by the
Right.
way, after all of this, and maybe I think that I can present a certain side of the argument, but is the judge going to actually agree with the defense? I highly, highly doubt it. I highly, highly doubt it. Now, this is going to be reserved for appeal, preserved for appeal, certainly, if they
Yeah.
try it again and Karen Reed gets convicted. But this is, I think, a very interesting, compelling argument.
Okay. One thing here. They couldn't render a split verdict, or they could render a split verdict. That just wasn't on the table.
Well, that's, I think what Melba's trying to understand here is that if you can acquit on count 1 and count 3, and then be hung on count 2, that's not a split verdict. That's a very clear verdict. 1 and 3 are out, and 2,
Yeah.
you're split.
Right. Okay. And then they would still have the opportunity to retry her on 2 if they wanted to.
Exactly.
Okay. So I mean, sorry, I just want to point out, Martin, this is so funny because you are so serious, and I obviously am not as serious sometimes. And you know what? That's why I think that this live stream is so fun, because you're talking very seriously and I'm talking about Bev being tired. So
Well, I mean, people's lives are at stake here. Can we joke about this?
wait, this is actually funny. Tommy says, watching this, living in a beach party town, Lauren is the party girl and Martin is the annoyed designated driver trying to reel her in. Yeah, that's pretty much what I thought too when I was just trying to crack jokes, which I should not be cracking. But yeah, so at this point, there's a lot of factors with Karen Reed possibly being retried here. We've got obviously Michael Proctor, who was recently suspended without pay yesterday. We've got the federal investigation, which is ongoing. And now we have this. And so I think all of these issues are just making my mind go insane. And I'm just wondering how the state is going to navigate this if they want a retrial, which if you watch the interview with Paul O'Keefe, it's very clear that family, the O'Keefe family, very much wants to continue to pursue this.
Yeah, and it's not up to them. But yeah, they are completely sold on the Commonwealth theory, a hook, line, and sinker. And I think that's also what I find. Like I mean, I just feel my heart goes out to the O'Keefe family. I mean, I can't say this enough. I mean, no one here who believes that there is reasonable doubt or talking about the merits of emotion, that doesn't mean that we're not here for justice for John O'Keefe. And the whole story is there's no winners here. This is terrible what happened here. And I feel my heart completely. You watch Mrs. O'Keefe. I mean, it's terrible. She lost a son. She lost a daughter. She's going through hell and back. It's really, really terrible. And, but they still are completely sold on the Commonwealth's theory in this case. And, that's part of the sympathy that you have, is that they're not able to really see another side of the story and maybe push the Commonwealth to actually find do better investigation or find, who actually did this or, what really happened.
Yeah. No, I feel terrible for them. And I do hope there is justice for John somehow, because I think so many of us are still like, what the hell? I mean, just not, talking about this too much, just because at this point it's just nonsense, but each side so firmly believes in what they believe in, that you would think that everybody was there. Everybody was there because everybody knows definitively. And that's where I'm always just like, man, I still have questions. I still 100% have questions, but
right, which is why I've always said, I don't know what happened. All I can tell you is legal standards. And if a side has met their burden, and that's why I'm just telling you, after seeing all the evidence come in this case, I just don't think that they've met their burden. That's all. I don't know what happened. I can't tell you I know what happened. Was Karen Reed involved somehow? Maybe. But should she be convicted based on this trial? No, I don't think so.
No. And like I said, murder too, I think we can all agree that was a huge, huge reach. I mean, or most of us anyway. But I want to take hold on, let me see. Martin, Tommy, is Martin blown away that the jury could even be hung on manslaughter? I just can't see how anyone can think a car hit him. All other things ignored. The car did not hit him. I mean, yeah, if you're going by crash daddies and you're going by, let's say, the medical examiner and possibly Dr. Marie Russell, their testimony on what happened to John, the lack of injury on his body, I can see that too. But again, Martin, I'll let you answer.
Yeah. Well, I'll tell you, first of all, I'm not blown away by anything. Okay. If you've been in enough trials, if you've tried enough cases, you're not blown away by anything, because juries do all types of really interesting things that you're not expecting and that you don't think, is going to happen, and happens. So I'm not blown away by it. Do I believe, again, that there's reasonable doubt that Karen Reed hit him with the car at all? Yes. I think that was extremely clear from the trial, from the biomechanical engineers, that nothing in this case is consistent with the car hitting John O'Keefe. There's just nothing consistent about it. The only person who can say that there's something consistent was Trooper Paul, whose theory was a little ridiculous. So there's really there's no expert who has testified. Yeah, I know that there's some pieces of taillight found in John O'Keefe's clothes, assuming, that could happen in a million different ways. But am I blown away? No, but I don't think that the jury should have been hung on that. I still think that based on the evidence that I saw in court, there should have been an acquittal across the board on everything. Anything that has to do with the car hitting John O'Keefe. Yeah. To my mind, there's reasonable doubt. Certainly, I think there's much more than reasonable doubt. But just to work within the burden that they're required to prove, it's not reasonable. There's certainly reasonable doubt here.
Yeah, I fully agree, and I agree with you, Disney. I can't say what happened either, but what I can say is the ARCA crash daddies, through their science and physics, proved to me that OJO was not hit by a car. So I think everybody is in it, or not. I shouldn't say everybody, but those of us chatting about this right now are in agreement there. I want to go through the last couple minutes and just see if anyone has questions for Martin. If I missed any, I'll go through. My mom met the burden, though. That's nice. Thank you so much.
I'm gonna just say probably an unpopular opinion, because I say the truth, what I perceive it as, what I see it from my experience, and I know that people are all against the judge here, and her was it her brother, Representative Collin or something, and so
Chris Albert,
whatever it is. I'm telling you, okay, I watched the trial. I literally watched every single minute of this trial, and like I've said already a number of times, I don't like the way that the trial was run. I think that there should have been more leeway on cross-examination. I think that the objections, without any explanation or basis or for the rulings, I think that there's certainly what to be desired. I did not see bias. Okay, I just didn't see it, and I've seen bias in plenty of cases. But so I did not see bias here. I saw a certain way that she likes to run the courtroom. I didn't agree with her rulings. I never agree with all the rulings that the judge makes. But again, I don't think that there's bias here. I don't think there's anything really that I saw, anything nefarious or anything that's even questionable in terms of conduct, in terms of this judge, at least from what I've seen during the trial.
Can I just say one thing? You didn't see that, we sat there and heard what, if anything, about the blizzard, about your trip to Aruba for a full day. And then we heard, does this have a point, Mr. Jackson, after 5 minutes? You don't think that she was a little bit impatient? And I get it. Defense attorneys, they put on a show, right? I get it. But you didn't see that I can't even do it enough. You didn't see that?
I know what you're talking about. And like I said, and I try to explain this a little bit. I think that if you're in the defense's shoes a lot, you'll see this. The defense is almost always at odds with the judge, okay? Because the defense is always trying to push and push and push. And the judge, a lot of times you find this, and some people that don't understand or are not there often enough will think, oh, the judge really has him against his defense attorney. It's just not true. It's just that the defense is always trying to push because they have a very hard job to do by defending this person. And the Commonwealth, the state, the prosecutor has all of these resources at their side. They've got all the policemen and they have all the resources of the state behind them. And you're just one guy on the other side trying to create reasonable doubt. So you're always pushing the ticket. You're always trying to, and a lot of times that annoys the judge, or the judge sees kind of through what you're trying to do. I did see some impatience, but again, I also saw that there are certain rulings that she could have made in favor of the Commonwealth that she didn't. And if she was really this terribly biased judge, she would have made those rulings in favor of the Commonwealth. So I understand what people are saying. I understand it, and I
Mhm.
get why they're. But I think that if you're a lawyer and you watch this and you've done enough trials, I don't think you
Yeah.
would have seen bias. You certainly would have seen, like what I said, certain things I didn't like, certain things I didn't appreciate, certain things I don't agree with, but
Mhm.
I didn't see bias.
Yeah, I mean, Tommy made a good point too, and I totally agree with this. She definitely gave Alan Jackson a lot of wiggle room. There was a couple times he spoke to her with a tone that I was like, "Oh," I was like, "That's a little borderline," and she did let it go. And yes, I think Alpha, she was impatient with Lally towards the end. Absolutely. I think that what I was thinking of, and I know that it could be argued, was when they allowed, I think it was Allie McCabe to first talk about the harassment on the stand, and Bev had said, "You open the door." And opening the door, I guess, was that the defense asking the same questions to every single witness, and this just happened to be her answer. But I was just like, oh, okay. Well, I thought that was a little interesting.
Yeah, I mean, look, opening the door is, it's one of those areas where it's not clear cut exactly what's considered opening the door. How
Yeah.
far away is opening the door, and I've seen where judges have said, "Oh, you opened the door," and I'm like, "What did I didn't open the door," and they say,
Yeah.
"Well, yeah, because now
Yeah.
so it's a judgment call. It's a discretionary call. She
Yeah.
allowed it in, and you can argue it one way or the other.
Okay. What do you think of the hearsay exception, not objection? He corrected himself. Was it not for truth of matter asserted, not hearsay, R.A. Proctor's text, state of mind?
Yeah, I mean, first of all, the state of mind there is very clear, right? He wanted to make it clear, cut and dry, right away,
Mhm.
and certainly that goes to the state of mind. Again, when you're getting into the exact which text messages is allowed in, which isn't allowed in, and you can start arguing hearsay, from today to tomorrow. I'm assuming that this was all done in pretrial motions, or they've had some sort of stipulation. A lot of times you don't have to do it through motions if you can just email back and forth with each other. Okay, are you going to have a problem with these text messages? That I believe they come in because of these reasons. And they may say, okay, we'll give you on those. We'll get, fight back on the other things. And it's all a chess game. So yeah, you can certainly make arguments that those text messages are not hearsay.
The pretrial hearings, the stuff she let in versus kept out seemed off. I mean, there was zero chain of custody on anything Proctor touched. How does it come in? I have no idea.
Well, okay. I know that there was an argument for chain of custody. Okay. But really, there's some different arguments here. And one of the arguments was the fact that, well, there's no log of the chain of custody. Now, the fact that there's no log doesn't mean that there's no chain of custody. As long as someone testifies, yes, I bagged that evidence, I brought it into the station, and I put it in that room. And then 3 months later, somebody comes and testifies, yes, I took it out of that room and I brought it somewhere else. Or there's no log about that. That's a good argument to make, but that doesn't mean that there's no chain of custody. So there's some things left to be desired about how the chain of custody and the logs were kept, but it doesn't mean automatically there's no chain of custody here at all.
All right. I'm going back through to see if I missed anything. No, I think that we're good. Everybody seems to really like Martin. So again, please go and subscribe to his channel at Brother Counsel. And he's great. His analysis are generally under an hour, which I really, really appreciate because who has time?
I value everyone's time. That's why I try to keep it,
which is amazing, honestly, because so I see these videos and I'm like, 2 hours. I can't sit there for 2 hours and try to get through this, even at double speed. But yeah, so also don't forget to like and subscribe Pop Crime TV. I would love that as I try to grow this. And I also I do put everything into a podcast, an audio form. You'll see it in the corner. That corner, the Outlier, which is available on all podcast outlets, all audio outlets. I'm gonna try to get it on YouTube. I know I need to do better about that. Just the audio anyway. But
you're doing great,
guys. Well, thank you so much. And Sal, thanks again. And someone said, let's get rid of Aunt Bev. Oh, Sheila, thank you so much for joining and being supportive. All right, guys. Thanks so much for joining. Martin and I will do another live stream soon. Maybe we'll do one about Baldwin together. That will be fun.
That's coming up. Jury selection today.
today. Yeah, I'm not interested as much in that as opening arguments or statements, but
Well,
yeah.
actually, Lauren, jury selection is so interesting. If it's
Really?
done right,
I'm like, I don't think it's that interesting, but
it
yeah.
is so. I'm telling. I put a lot of thought and time into exactly the type of questions I'm going to ask. I know that a lot of attorneys don't. I
Yeah.
do, because I think jury selection is so important. If it's done right, it's done
Mhm.
properly, you can really weed out which jurors you don't want and which jurors are going to maybe be on your side. So
Yeah,
I would
staying
love
silent.
nothing more than to see jury selection, although they never live stream it. So I mean, I really would
Yeah.
like to see jury selection.
Yeah, and Martin, also thanks for getting me home safely. Seriously. Tommy says, anyone following the Baez trial in Florida, murder for hire? Oh no, but I am a fan of Jose Baez and his work, so I will have to check that out.
Is that
Interesting.
the Shayna Gardner one, or no, that's something else?
I don't know. Tommy, what is
Yeah.
that?
All right.
I don't know. Anyway, we'll get to it. We'll plan another one. I will I'll put everything on Twitter. Oh, follow Martin on Twitter too, you guys, at Brother Counsel. He literally is so bad at Twitter. Oh, hi, Sleuthy. Yeah, he's horrible at Twitter, but everybody should go follow him so we can boost his presence, and he can actually post about things instead of just telling us when his YouTubes come out, which is great, but please go follow at Brother Counsel on Twitter, and obviously YouTube as well. And me, I'm at Conlon_Lauren, and I'm here. So, okay, we're really going to end this now because I do have to go pick up my children. So, all right, guys, thanks
Thank
so
you all.
much.